this up. Is this what you want me to? I wasn't going to sit. I was going to stand. Maybe you ought to hit the lights if I'm going to do this. Well, thank you all for coming, and thank you for the Rocky Mountain Inventors Association for inviting me back. I first spoke to the Rocky Mountain Inventors Congress in 1984. So I'm older than some of the people in the room. That was a while ago. And it was a very productive event for me. I got one of the best clients I've ever gotten out of that one, and he took his company public after he patented it. It was a long, good run, and it came right out of this group. So I have a soft spot in my heart for this group. Okay, I'm not a patent lawyer. I'm a securities lawyer. And because Gil Sellinger, who was an associate of mine, and now he's a partner of mine, decided to, his wife's having a baby right now. Okay? I won't say what he decided to do, but he did decide to go be with her tonight rather than be with us. And I think he made the right choice, and I apologize. Okay. The topic he was going to talk about was crowdfunding, its current, where it is today. Okay. And what I've been doing I didn't have a set of slides on this particular subject that was up to date. Okay. I'm happy to send out the set of slides that I did in January 2016 on this subject, and that's whatever, 15 months ago. I can't do the math, but it's more than 12 months ago. Okay. I will give you an update on that. I did have Roger hand out the slides which, for a talk I gave in Durango on April 11th to lawyers. And one of the things I'm doing this year, because I like lawyers not to make mistakes when they go out there and talk about something they don't necessarily do every day. Because I'm sort of a lawyer's lawyer. People call me and I said, nah, you can't do that. You should tell your client to do this and you'll be okay, you can do it. Or, you shouldn't get into that unless you get it. Many lawyers don't have securities malpractice insurance. It's an add-on to most of their stuff. And so I talked in Durango, and I'm going to use basically the same slides that you see before you in Grand Junction, Fort Collins, Summit County, Colorado Springs, Lakewood. This is my 5-year run around the state to help general practitioners. I used to be a solo practitioner. It's hard to stay up to date on things, and you don't want to bet your house unless you know what you're doing. You understand lawyers don't have to have malpractice insurance in Colorado. Most of them do, and I highly recommend it, having been on the receiving end of grumpy investors who will sue anybody in sight. That's part of the risk of being a securities lawyer. But I will make a couple references to the handout. At the end of the talk, I'm going to give you an article off our website. And fundamentally, pretty much everything I say is in that article. But I'll give you the article now, you won't listen to me, you'll just look at the paper, and that won't get you where you want to go, particularly if you start interrupting, which is perfectly okay. So do people want to hear about crowdfunding and where it is, the subject of the talk? Okay, I'll tell you. Okay, I'm happy to do that, okay. In a nutshell, and this is today's news, the crowdfunding is here to stay, but equity crowdfunding, the way the SEC conceives of it, is a pretty slow starter. Okay. Regulation crowdfunding became effective on May 16th, 2016, so it's after the talk that I gave last year, which is based on the regs, the final regs. But in February 2017, the SEC staff released a white paper on how it had been used from May 16th through December 31st of last year. According to the white paper, there were 163 separate offerings by 156 issuers throughout that period, with those issuers seeking a total of approximately $18 million, which is peanuts if you think about how people raise money in this country through offerings that aren't public offerings. Okay. By the way, 1.4, well, I remember the statistics from 2012 when the Jobs Act first came out. It was some god-awful number of I think it was not trillion, but $1 billion was raised through private placements. Several $1 billion through private placements under 506B offerings, which is the common 99.95% of the time you're going to use a 506B offering, which I'm going to talk about because that's what people are still doing as an alternative to this. Okay. The most frequently offered security and equity crowdfunding, according to the SEC way of defining equity crowdfunding, which is their crowdfunding exemption, was equity, selling stock, okay? Followed by SAFE, if you guys know what a SAFE deal is, simple agreements for future equity, and then debt. Debt is, I'm going to go through what a security is, and you'll figure this part out in a second if you don't know. The median target offering amount of these 163 offerings was $53,000. The average offering amount was about $110,000. Almost all the offerings accepted oversubscriptions up to the max, which was up until April, it was $1 million is what people were allowed to invest in crowdfunding. In their crowdfunding offerings, you could seek $1 million per year in a crowdfunding if you were the issuer. Now it's up to 107,000, something like that. As of January 15th, 2017, approximately $10 million in proceeds had actually been raised in 33 offerings, with the median amount raised at approximately 171,000. The average was 303. Those sound high to me. I've seen other statistics that said during this is not SEC numbers, but it was basically about 113,000 was raised. So they're not raising a lot of money through these offerings, okay? Yep. There's the white paper. I went and looked for the white paper, but I couldn't find it today after we decided I would give this talk. But we can dig it out for you. But it's just history. The median issuer had under 50,000 in assets, under 5,000 in cash, 10,000 in debt, no revenues, and 3 employees. So it's small. Okay. For offerings initiated in 2016, 24 were withdrawn by issuers. Right. So that's basic. Sorry. No, what they were trying to raise was 53,000 in a median target. Average offering they were trying to raise was 110. There are other ways of digging up statistics from other people. FINRA, which used to be called the NASD, would probably have statistics on this because remember you have to use an intermediary, which could be a portal or it could be a broker-dealer, and the FINRA is involved in keeping track of all this stuff. So. But those are the statistics, okay? I'm not a big fan of crowdfunding, so I ought to get that out there before anybody. It's an awfully long run for a very short slide, and professionals don't like to touch little bitty deals like this, particularly accountants. That's why I can tell you a lot of problems with equity crowdfunding at the federal level. But those are the stats that I know, okay? Do people want me to go through some of the basics of equity crowdfunding? Because it hasn't changed very much, except they've just raised the amounts because of inflation. Remember, it used to be $1 million, now it's $1,070,000. Sorry, go ahead, Dave. Well, there's a lot of, right, okay. Well, let's just start, let's do something first. Okay, for those, this is Securities Law 101, okay? There is a comprehensive scheme in the United States at the federal level and in each state that requires when you go to sell a security that it be registered or it be exempt. You go to a securities lawyer, say, find me an exemption, because God knows I don't want to file with the SEC and I don't want to file with the state because there's criminal penalties if I file a mistake. So you don't want to do that, okay? And to make sure, help me with disclosure, securities lawyer. Make sure I don't get sued successfully for 10b-5 fraud. So that's why people come to me. There are many securities law exemptions, many, okay? So what I want to say right now is what is a security and what are the exemptions? So in what I gave you, if you got one, this is what I'm telling the lawyers. Okay. Look at page 4, definition of a security. And I saw an eyebrow go up when I said promissory notes, but the very first word in the definition of security is any note, stock, security, future, bond, indenture. I mean, I shortened it up, but fundamentally, a lot of things are securities you might not otherwise think of. So go to number, go to page, skip the lawyer stuff, go to page number 7. So securities, a lot of things lawyers don't think of as securities, and probably you don't think of as securities either because you're used to stock only. Limited liability company membership interests, general partnership interests, fractional undivided oil and gas interests, tenancies in common in real estate, okay? Real estate, if you have a pure tenancy in common, it's not a security, but if you've got a common management agreement, boom, you got a security, at least as far as the SEC is concerned. Municipal debt, like municipal bonds, municipal notes, mutual ditch company shares. Now, this was in Durango that I gave this talk. I'll fight to the death to tell you guys that the mutual ditch company share is not a security because our law firm represents, we have water lawyers who represent some ditch companies. But certainly there's a debate going on about that one. Franchise agreements. We don't have a franchise law in Colorado. At least 17 states do have franchise laws. Remember, there's federal law and there's state law. So the states differ from state to state as whether a franchise agreement is or is not creating a security when somebody buys a franchise. In any event, there are many kinds of securities, and if you got a question about whether something is a security or not, give me a call and I'll tell you what I think. I mean, I have lawyers calling me, telling me, John, is this a security or not? I say, well, no. Thanks for calling, though. Keep it short, or you buy the beer, I'll tell you whatever. Okay. So the point is it a security or not? If you've got a security, then we've got to find an exemption for it. I'm answering the question now. Okay. So there are many exemptions, and look at the page 8. Okay. Again, all the exemptions are really discussed in this article on our website that I'm going to give you at the end, called Information for the Small Business Person Interested in Selling Securities. The easiest exemption is there are in the statutes like the 33 Act, the Federal 1933 Act, which deals with the initial creation and sale of a security, which requires the registration if you don't have an exemption, registration with the SEC. The most common exemption is a private placement exemption. And that private placement is basically for offerings not involving a public offering. Public offering is not defined, but okay. But we know it when we see it, okay? And the only Supreme Court case is a case called Ralston-Purina. And fundamentally, it basically says, this is a self-executing exemption. You don't need a SEC safe harbor. You don't need Regulation D. You don't need regulation crowdfunding. You can use this. But it basically says access to information. So the gravamen of 4A2 is you've got an incredibly wealthy person who can buy all the access they need, and you sell them a security. That's a private placement. It's not a public offering. You're not no general advertising, no general solicitation. Yes. The credit investor has nothing to do with the statutory exemption. Okay. 4A2 is simply talking as the issuer. Okay. So if you want to sell me stock, and it's just you and me, it's exempt because it's just a private placement. Because this presumes that the shares come to rest in me. I don't turn around and resell them to somebody else. If you sold me and I sold to somebody else, I could be an underwriter, a broker-dealer. Okay? So you want me to tell you that I'm buying for investment only and not for resale. I mean, around each of these simple exemptions, there's a bunch of lore and rules that allow you to be sure that you haven't used an underwriter to sell to this guy, which gets you in trouble. Okay, you've got to know where the shares are coming to rest in that. I mean, there's pieces to it. But basically, 4A2 is the common private placement exemption. And, sorry. No general advertising, no general. Right, right. Now, if you look at this list here, you'll see Regulation D go down about 4. Okay. Look at the last, under that fourth bullet, look at the last line, 506B. The safe harbor promulgated by the SEC with the power it gets under 4A2 is Rule 506B. And as I said a bit ago, 99.95% of all exempt offerings in 2012 were 506B offerings, according to the SEC statistics. That's because it's tried and true. It's been around for a long time. Before it was called 506B, it was called 146. I'm old enough to remember 146 because this came in the 80s or the 70s. I can't remember when it came in. Boom, it's the only safe harbor promulgated under the private placement exemption. So what many securities lawyers will want you to do is use 506B, and if you screw up the safe harbor rules, you can go back to 4A2 and you'll be okay, because 506B requires that your offeree be sophisticated or have the ability to bear the risk of the investment, and that your purchaser be sophisticated and have the ability to bear the risk of the investment. Now, the SEC made that up, okay? The ability to bear the risk. Sophisticated might be under courts made under 4A2, but the SEC just interpreted that to come to that place. So you got a regulatory agency in there, but I wouldn't bother to spend money fighting whether the SEC is right or wrong on that one. There's a lot of stuff out there. But the SEC makes mistakes just the way everybody else does. They're only entitled to interpret the statute. Go ahead. I'm being real simple. I hope I'm not boring anybody. I don't want. Not on 506. Unlimited. That's why the private equity funds and the venture capital funds use 506B as the safe harbor exemption when they go out and raise $300 billion. Then they'll file their Form D and check their box 506B just the same way you will when you want to do a 506B private placement, okay? Boom. Okay. Another exemption, just working through the statutory exemptions, the next most common one after 4A2 that you could use around here is the 3A11. Go down there, 1, 2, 3, 4, 5, 6, 6. That's the intrastate offering. There's another, oh, by the way, the reason you use 506B is because the SEC has said you preempt the states. Remember, there's 2 levels of regulation. The states can't stop you from selling if you have a true 506B offering. However, if you don't qualify under that safe harbor and you do a 4A2, then the state of Colorado and every other state in the country where you're selling securities can come in there, depending on how their state laws work, and mess with you, saying you didn't have the right kind of exemption or something. So everybody likes to use 506B because it preempts the states and keeps them out of there. And I remember before the preemption rules, upper Midwestern states are the toughest. I mean, Missouri, Michigan, Wisconsin, Iowa, those folks are hard places because they had what we call merit review. Colorado doesn't have that since 1981. But you can, in Colorado, you can go ahead and sell, and they try to catch you on the back end if you screwed it up. If an investor calls up and say, this is not a good deal, you know, they didn't do this right. So the Securities Commissioner will look first to see if he can attack the 506B safe harbor, because if he can blow out the preemption, then he can go after all kinds of things in the offering. Anyway, I've been doing this for 40-some years, so I sort of like it, but stop me when you're really bored. Anyway, 3A11 is the intrastate offering. That's another self-executing exemption. So if he wants to sell to me securities, and we both know we live in Colorado and we're resident in Colorado and the company is based in Colorado, the proceeds are going to be spent in Colorado, that's exempt at the federal level. However, you're not preempted at the state level. So the securities lawyer has to help you find an exemption in Colorado for this transaction. There aren't quite as many exemptions. There are plenty of exemptions, but takes you about 20 minutes to find the right one depending on the deal, okay? There's no safe harbor. So, but the nice thing is if you've got 3A11 or 4A2, you got some exemption in there in a small deal, okay? These are described in this little article, a little bit more detail, a lot more detail. The safe harbors under 3A11, the SEC has promulgated. The old one is Rule 147. And now they've also promulgated Rule 147A. Okay. And you can see these were effective in April. Okay. Now what these are is the SEC 147 basically says 80% of the proceeds. It goes into detail defining what the company really is. I mean, it gives you a little bit of out on, we can't make an offer or a sale under 147 outside the state, but it talks a little bit more about the number of proceeds, where the employees live and stuff like that. But 147 is the old safe harbor, okay? And the reason they had to change that is because the states started promulgating their own versions of crowdfunding. For example, RF crowdfunding is Colorado's equity crowdfunding exemption from the federal level. They did it under Rule 147, and in order to make these things work on the internet, the SEC has come along with 147A, which basically says you can make offers outside the state, but as long as all the sales are in the state. That's what 147A is. Problem is Colorado went before the feds, so now Colorado has to amend its RF crowdfunding to fit the way 147A works and not 147. Nobody's used our state crowdfunding. It's not an exemption. It's a registered offering at the state level. That's the problem with this. That's one of the big problems if you're a small company using that state exemption, because it's a registration. Securities lawyers don't like registrations. It's a crime if you make a mistake. We like intentional, knowing, or reckless things to be crimes, not negligent things, okay? So you can get fined, and maybe it's not a crime, but you can get fined and you can get banned from the security. There's a lot of bad things that happen if you just make a mistake with a registration. So find the exemption, okay?
Statistically, how many people are doing intrastate?
Nobody has done that yet in Colorado. There were 5, I didn't look at it this time, but a month ago a guy wrote an article about what was wrong with the state crowdfunding, okay? And I told you so. Okay, I told them so. But my idea of crowdfunding is that I'll be for small companies. Like I live in Park Hill, so the Spinelli's Market ought to be able to raise $200,000 if they need to keep their grocery store open. They ought to be able to let everybody know on the handheld device that they're trying to raise $200,000 and give everybody a piece of the grocery store and make that happen. And that ought to work for inventors too. That's not the way it has been interpreted by the Jobs Act or the states or the SEC. They've larded all this complication on it, okay, which is what I put into the talk last January a year ago. And it's just hard to work with. So you have to, for crowdfunding, you have to have a platform or an intermediary, okay? And it's state crowdfunding, you got to have escrow half the money, okay? Problem is nobody wants to hold the money. No bank wants to hold it. It only goes up to $1 million. Why would they want to do with that, take the risk? Because you can't, you're dealing with people that don't have a lot of money to give, to pay some. They tightened it. The first year they passed it, I said you need to make sure somebody will be an escrow agent to hold the money. Make lawyers, make real estate agents, make anybody who's licensed, you can take their license. Let them, people who can hold the money. Well, they didn't do that. They said banks, okay? So they go to amend it, and they made it tighter, not looser. Now you have to be a national bank or something like that, a national depository institution. But the trade associations, the bioscience and the software and the clean tech people, they lobbied it through, but it wasn't good. The guys who were writing this said, we can't get any looseness out of our securities commissioner. It's just, so the next year they came back and said, get them so they could get some escrow people to hold the money, and we can make these things. So then they made it tighter, not looser. So Jerry Rome is the state securities commissioner. He's an enforcer. He's a lawyer. He's never been in business. He's never invented anything. And he's a mean man. And I don't think he's very helpful. So I'm grumpy about state crowdfunding in Colorado. The last 3 securities commissioners were business people. They knew what they were doing. Yes, sir?
John, are you going to go the alternative of crowdfunding?
Yeah. I'm talking a little bit about it now. But the state crowdfunding, I had to touch on that. I mean, there's been no deals. There are 5 platforms. I can send you the platforms, but I just think it's a dead horse. Yes?
Of those 5 platforms, none of them have brought anything.
No. No, they have. You could, Carl Dakin, I don't know if you guys know Carl Dakin. He hangs out in the startup community. He's a good guy, smart guy, always ahead of his time. I appreciate everything he did to set up his website and be the platform and all that. And I gotta love him, because that was all out of pocket and nothing's gonna happen. But he's a good, if you want to know a guy who probably has a good website for intrastate crowdfunding, okay. So I mentioned, yeah.
What about other states? Or some better?
Half the states use 147, so they gotta fix theirs. Yes, some states are better, okay. But if you use 147, you can't use them because you got to be intrastate. So it could be, that's one way. Or, just answering that question, there's another exemption, Rule 504. This will give me a chance to talk about that. Rule 504 has just gone up from $1 million to $5 million. Some people would say Friday, I say today, being conservative. So now you can go up to $5 million on a 504 offering, which used to be $1 million in a 12-month period. It doesn't preempt the state, so every state has its own rules. Some of the state internet offering rules were under 504, not 147. Okay. Those states that did 504, okay, then now they can go up to 5 million. That's a place, if you have enough contacts with the state, and I haven't gone through all the different states to try to figure out who's a 147 state and who's a 504 state, okay? But Colorado's a 147 state, and here you are. So unless you want to move, it's hard to get a securities commissioner in Maine, make it up, to say, yeah, I'll let you guys run a unregistered offering using general advertising and general solicitation on a website based in, or that goes through Maine. I'll let you guys. They don't think like that. They think, why can't you run that back in Colorado? That's how they think. So But 504s are, if you stay off the internet, 504s are where all the, I used to be a solo practitioner. I did a lot of microbrewery deals. So we used 504s. I mean, it wasn't one of mine, but well, Mile High was a Reg A, if you remember Mile High Brewing Company, but a lot of the brewing companies in the 90s were done under 504s to get their startup money. Okay. But 504 is a commonly used exemption, but you got to find the state exemption that goes along with it. Okay. But now that it goes up to 5 million, I expect it to be used. 506C is the one that the SEC had to write because Congress told them to in the Jobs Act. And I've done some 506C offerings. What happened there is Congress said, find a way to use 506 to do general advertising and general solicitation. Remember I told you 506B is the one that everybody uses. No general advertising, no general solicitation. So the way people use 506B on the internet, and they have for years, is somehow the investor goes to the issuer website, gets a password, goes behind the firewall and can see what the deal is. You can't just go sending out that prospectus, okay? 506C, if you can offer to anybody, but you sell only to accredited investors, and you have a process for verifying their accredited nature, then you can do general advertising, general solicitation. And it preempts the states, which is helpful, again. But people, you can have, all your investors can be accredited, but if you don't have a process, for a standard process for verifying them, you lose the exemption. This is the SEC. Okay? So you've got to set up a decent process for verifying, and sometimes people, people lie. They say they're accredited because they want to see the deal. Okay? Maybe they're not accredited for some reason. Okay? But in the main, it's going to be used more. It just hasn't been used much yet. It's because the people, you have to have a prior existing business relationship for a 506B, in theory. Okay? So you can't join the country club to meet the people to do the deal. But if you've been in the country club, met the people, and 6 months later you go out to them, it's okay. So you got to draw that line in there somewhere. Prior existing business relationship. That's the SEC talking because of their exemption. That's not in 4A2. Remember, 506B power comes out of 4A2. So the SEC, their safe harbor says prior existing business relationship, but not under the 4A2. Okay. So when you go, just a little bit about websites. When it all came at me two or 3 years ago, okay, oh, John, these guys are selling this way, why can't I? These guys are selling that way, why can't I? So I would go look at the websites, okay? So when you are looking at a website, a lawyer has to reverse engineer to figure out who's doing what on that website as a platform for raising money. There are good broker-dealers and there are crappy broker-dealers, but broker-dealers are a legitimate form of raising money. You have to pay them a fee, and they set up websites. They can have a broker-dealer website will work. Boom. Okay. There are websites for registered investment advisors. So what you're basically doing when you go, a broker-dealer, remember, represents the issuer. The registered investment advisor represents the guys with the money who are going to make the investments. So there are websites set up, I think AngelList is like this. I mean, they are financial advisors to the investors in the group, okay? There are websites that simply want to collect the names of every accredited investor they can, and they sell the list to somebody, okay? And then there are these platforms that exist under 506C. Well, these ones to accredited investors have to be sold on a broker-dealer or an intermediary platform that's a member of FINRA. FINRA, remember, is the old NASD, which is the Trade Association for Broker-Dealers. So if you're not a broker-dealer, it's pretty damned hard going through FINRA competition being what it is. But I read you some statistics of people who are using those websites. So you've got to sort of reverse engineer the website to figure out what's going on. And I tell this to the lawyers too. You know, if you can't figure out what the website is, give me a call. I'll go look at it. I mean, I'm an accredited investor. I can not lie and go into that website and dig down deep. Problem is then I get buried with emails saying, hey, don't you want to look at this deal? Don't you want to look at that deal? But so I think I've covered bases on the alternatives to crowdfunding. Maybe not. Let's see. 505 is eliminated. Nobody used it anyway, so don't worry about it. Okay. A good securities lawyer can mix and match the exemptions. You can basically be running 2 or 3 different offerings at the same time if you know what you're doing. You use one kind of offering for one kind of investor, a different kind of offering for that kind of investor. Because if you can't do that, there's something called the integration rules, which says you can't take what would be a public offering and chop it up in little pieces and say it's not a public offering. So you've got to work with the integration rules so all these things don't get pulled all back together and called a public offering, because that has to be registered. Remember? Okay, public offerings have to be registered, unless they're 506C, general advertising, general solicitation type things, okay, to accredited investors only. Now, if you want to sell to unaccredited investors with a 506B offering, accredited investors are people who are millionaires, not counting their house, unless the mortgage is more than it's worth, okay. Or people who made $200,000 a year for each of the last 2 years and expect to make it this year, or with their spouse $300,000 a year. Those are accredited investors, okay. But if you do a 506B offering, remember it preempts the states, but you're selling to unaccredited investors, then there's a specific list of things you have to tell those people. And if you don't tell those people that, boom, you lose your exemption, okay? And all these exemptions are just fine, but you can't materially mislead an investor. So you've got to disclose all the material facts that a reasonable investor needs to know under any of these exemptions, state or federal. Exemptions are one thing. So if you're trying to raise give them the shoebox, give them everything. But if you want to, if you have to hire a lawyer to write, you're in trouble, because you don't want the lawyers to spend time writing. You want them to spend their time reviewing things and tell you what exemptions, and tell you what's missing in what they read. You don't want lawyers writing. Lawyers, time, Abraham Lincoln, a lawyer's time is his stock in trade. So you don't want me spending any more than 10 or 15 minutes looking at tell you what the exemption is, and another 25 reading your business plan. And you're going to need risk factors. You got to have that. But I'm a big fan of not making offers to unaccredited investors in the 506B offering. Use the 147 and the 4A2 for your seed round, family, friends offering. Am I covering the bases? I mean, I could give you a lot about crowdfunding theoretically. It's just not going anywhere right now. Okay.
I think it's important to give what's operable, what's the best
well, sure.
way to go, and if it's not crowdfunding, then I understand.
Yeah, the safest way to go is 506B, 506C, tried and true. I mean, people get into habits, investors get in habits, and you want to make as fewest barriers possible to the investor writing the check or giving the cash or however they're going to make the investment. So, I mean, there was a guy called Fred Hamilton. He's dead now. He was an oil man, and I was hired for a day. And I went in and talked to this guy, and he's a wealthy guy. He said, "Why are you here?" After about 10 minutes. I said, "I'm here to convince you that you should not run your brand new tech company as a limited liability company. You should be a corporation, because it's really expensive to do the operating agreements to satisfy all these terms that you want." And he said, well, it wasn't a limited, it was a limited partnership. He wanted to make it a limited, and he said, "No, I only invest in limited partnerships." I said, "Yeah, but the partnership form is bad. I mean, you can't do this, can't do that." He said, "But I only invest in limited partnerships." It didn't matter to him one damn bit how hard it was going to be for that entrepreneur to satisfy what Fred wanted. Fred only had so many hours in the day to throw at this. He wanted a limited partnership. He understood, and limited partnerships are an older version of what's been overtaken by limited liability company suggestions as entity choices right now. But a limited partnership, there's a lot of law. It's been litigated in many states. It's a very common tool, and venture capital and private equity funds are all limited partnerships because that's what the big institutions want, and that's what Fred wanted. So I went out the door unsuccessful and got paid for my hour and a half, and that was that for my poor guy who company didn't go. I mean, it was just, I don't know who did the law, but it was hard to do. But if a guy wants something that's green, give him a green stock certificate. You know, it doesn't have to be a red stock certificate. Give them something, give them what they want. If it doesn't matter to you, that's sort of my theory. In any event, there are plenty of exemptions. The online stuff is all going to be 506B or 506C. I do law work for the Rockies Venture Club, if you guys have heard of that. They do good work on this kind of stuff. It's many people who've come out of this group have gone over there and raised some money. It's the kind of thing they teach there. They're entrepreneurs in the programs that they do. I think I went to one of those. I mean, I know they do good enough. I'm not sitting here saying it's all perfectly lawyerly. No lawyer wants to sit there and do teaching, but I think they're a pretty good way of learning things. I mean, Roger knows a lot about this, not his area, but he knows a lot about this kind of stuff. So, okay, I mean, you want an hour. Have I taken an hour? Yeah, go ahead.
You mentioned 4A5 and 4A6.
Yeah, 4A6 is crowdfunding. It's not self-executing, so you got everything I said. They had to have SEC rules. It is 4A6 crowdfunding is not self-executing. The SEC rules are the law for that. 4A5, the reason a lot of people don't use that, because you've got to prove that both all your offerees and all your purchasers are accredited. Now, you can probably do that with your accredited, but it's pretty damned hard if you talk to 50 people and only 2 invested to be able to prove to the SEC that the other 48 were accredited. It's real hard, okay? Now, you can do that if it's the 5th time around, you know, and with the same 5 guys. I mean, this probably works in the Silicon Valley out in the backyard over the barbecue because everybody knows everybody. But out here in Colorado, it's a little bit harder to do. Excuse me. But, I mean, there are probably some other exemptions I didn't cover, but I don't think that they really apply to the, I mean, there's something for municipal bonds, but we're not doing tax-exempt deals. Go ahead.
So crowdfunding platforms like WeFunder and such that help you raise.
Is that like Indiegogo and, okay, they're not selling securities.
Well, they're selling they're doing it as an equity.
Well, okay. I mean, I have to look at the deal.
So they're like it's through the A+. So they'll help you raise a certain dollar figure. Are you familiar with that one?
I have to look at it. Now, Regulation A, Reg A, is an exemption from registration. It's a limited offering exemption the SEC promulgates. I didn't put it in this list because you don't see many of them. I have actually done Reg A offerings. We did them back in the beer days. There aren't many. You got to be older to have messed around a lot with Reg A. One thing the Jobs Act did was it told the SEC to expand Reg A. So they call it Reg A Plus, if that's what you're talking about. Okay. There's Tier 1 and Tier 2. Okay. I think the Tier 1 is the old-fashioned Reg A. It goes up to about 20 million. I'll give you a handout on it's in the handout, okay. Reg A Tier 2, the plus stuff is before the final regs came out. Now they talk about Tier 1, Tier 2. Tier 2 is up to 50 million. And there's a real deal there. I mean, you got to have audited financials and stuff, but it is significantly cheaper than a public offering. So what they're doing is jamming something in between the 506B and the registered IPO. Okay, now they still do reviews of these at the SEC home office in DC, by the same people who do the IPO registered reviews, okay? And they have a trouble. I mean, I've read, there have been a number of them, maybe 25 or 30. There haven't been as many tier 2s as you want there to be, but there are more tier 1s than they used to get, up to 20 million, okay? And the problem the SEC has is once they start looking at something, they can't let it go because they're used to this standard and they can't have a lesser, they don't follow their own regs, excuse me. But I would love to do, the first opportunity, I saw a really good opportunity for one, like 3 weeks after it came out, and the guys called me up and I went out to look at their operation. And I mean, I would have loved to do it, but they were doing R&D in the marijuana industry, okay? Everything was perfect, except it's still a Schedule I Controlled Substances Act problem for hemp research, which is all the farm, a lot of my relatives farm. I mean, come on. But in Canada, you could do it like that, but not down here. And most of my license depends on the federal law, and Jeff Sessions is our worst nightmare in the marijuana business. I'm sort of glad, I'm really glad that I've kept this, we're all around this stuff. We represent the landlords, we represent the guys who own the trucks, we have the software companies, but we don't touch our clients don't touch the plant. But I would have loved to, that was a good, company been around for 15 years, they did a lot of other things, but it was like a testing and research thing, and they'd gotten into hemp, but they jumped ahead of, they had relied on the website for the Western States Governors Association page that talks about legalization of research into hemp. And it said it was now legal, but that wasn't true. They got into it, and the actual fact was that the feds hadn't amended the statute yet that allowed this to work. And you got to talk to lawyers when you go jumping around in controlled substances. That's not us, but somebody who knows that stuff. Sorry. Is that responsive? I mean, I've got the handout that will talk about this. Okay. Yeah.
Consider a promissory note as security?
Is it less than 12 months in duration? If it's over 12 months, you got to. If you look at this piece of paper here, I'm telling the lawyers, assume a note is a security. This is page 6, okay, unless it fails the test. Well, you got to look at the Howey test, which is page 5. Howey test says, I mean, if you don't know what it is, if it doesn't fit the statutory list of things, but it's some kind of written contract, then if you've got an investment of monies with an expectation of profits arising from a common enterprise, depending solely upon the efforts of others, you got a security, an investment contract. And the fights are about solely, and I've been an expert witness on this stuff, and judges have bought my argument that it's not an argument, I was telling that's the law, okay, that it wasn't a security. In real estate development, when people sell developments, the real estate's a big area for is there isn't a security. Okay. But now you go to the note page, page 6, and we have a confusion in Colorado. Okay, assume a note is a security unless it fails court-made tests for both federal statutes and applicable state laws. Okay, so I was wrong in this page. Okay, I said that I am not sure that the Colorado test is still the Howey test for notes. Okay. Somebody showed me another case after I gave the talk. But the federal notes test isn't the Howey test anymore. It's this familial resemblance. If it walks like a duck and talks like a duck. I mean, a bank is a 5-year promissory note. Secured by real estate. One issuer, they're going to hold the note, and they got the mortgage. That's probably not a security.
Right, because even though it's invested in the business, it'd be like an inventor running up a bunch of credit cards.
Right.
So the credit card agreement just says, okay, this is unsecured debt, you have to pay back on certain terms.
Right.
But nothing is
credit card issuer didn't, or the guys from whom you're buying stuff didn't intend that this be a security. I mean, this
It's
bottom test
separated.
is that, but it's subjective. I mean, it's all focusy. It's hard to know everything. Credit card debt, I understand. Guys, 8, 9, 10 credit cards to make payroll. I'm familiar with that problem. Okay. But the Colorado law, I need to check on that again. Okay. But I know the problem is you got to deal with the most. I mean, I should know the answer on the Howie thing, and I don't. I'm sorry.
But how is there no kind of condition based on business succeeding? That's
Well, part of this is, you know, who's the guy out here? I think, you know, I will loan you $20,000. Okay, I want to get 15% return, and you know, we'll wait 3 years to see how it turns out. I want your personal guarantee. That's a security, I think.
because it's really,
I mean, I'm betting on your success, and
you're
I don't.
depending on the success of the investment.
Yeah, I don't even do it, just give you the money and take the promise. You know? So it's sort of, I mean, why do people want to find a security? There's a question, if you're a creditor. Okay? Because there are 8 elements to common law fraud, but there are only 4 elements to securities fraud. Okay? So it's a whole lot easier to prove fraud if you find a security in the deal. Boom. So you want to try to avoid the securities laws. Forget about the registration stuff. You just want to avoid it. Say it's a straight debt, okay? So that they can't just, you know, they can always sue you for anything. Okay, you can sue for anything anytime. Okay? But liability is the bigger thing to worry about. If you can avoid liability, the settlement will be a lot lower. But I forgot to tell you, you want to stay out of the securities game if you possibly can. So I mean, I was going to do a deal in a small town, and their lawyer referred it to me because he wasn't covered by the securities law. They wanted to raise $1 million, $1.5 million. And we started on it, and I explained everything to him. And I said, we're going to need financials to do this. You got to get your accountant to gen up some financials. And their accountant decided to put the money in. Boom. Who knew? Fine with me. I don't know what kind of deal he did. But they were trying to avoid the securities laws. So he loaned him the money. Well, he's not active in the business. I was sort of like to see how that deal, but I'm not, you know, I didn't work on it. So whatever, you know, it seemed safer. It sure saved them the legal fees. I mean, they didn't have to pay me. But the company's doing very well. I would love to be their lawyer, but their regular lawyer is their lawyer. So okay, how am I doing? Okay. More questions, concerns, issues? Done? I mean, you've got my, I'll hand out these other things. You can always drop me an email or give me a call. Keep it short. If we're going to meet, you've got to buy the liquids. Scotch is good. Beer is also good. I'm okay for it. Thank you.